Hey everyone, welcome back to the channel. Today's case is a wild one. We're looking at a sovereign citizen who's somehow also active duty military, along with his Karen-level sovereign citizen wife who manages to turn a bad situation into an absolute disaster. Before we dive in, I need to say this, as a veteran, it's genuinely concerning to see sovereign citizen ideology creeping into the military. Every service member swears an oath to defend and uphold the United States Constitution, not some fringe reinterpretation of it. Seeing that mindset in uniform is alarming. Stick around, because at the end of the video we'll break down some of his spectacularly frivolous court filings. Let's get into it.
Record in Johnson, that is case number 2024 TR 22, State of Kansas versus Danny Johnson, County Attorney Jill Gillette for the state. Mr. Johnson appearing in person and pro se. Your name tag on your uniform says Johnson, so I presume you are Mr. Johnson. Now, sir, if you could get right in front of that microphone, thank you.
Can you hear me?
I can. Sir,
Yes.
You're charged in count one with speeding 82 miles per hour in a 65 mile per hour zone. That is a traffic infraction. It is not a charge that carries any jail time. It has a scheduled fine. 82 and a 65 is $87, but then there's also 108 court costs. In count two, you're accused of operating your motor vehicle without proof of insurance. Now, if you had insurance but just couldn't find it, you can get the proof to the county attorney and she'll probably dismiss that charge. If in fact it had lapsed or something was happening so that you didn't have insurance on the vehicle at the time being January 4th, 2024, that is a B misdemeanor. The maximum penalties as far as jail time would be 6 months, although probation is usually granted. There is a mandatory minimum fine the court must impose of $300, but it could be as high as $1,000. You do have the right to hire any attorney of your choice. If you cannot afford an attorney, you can apply and see if you qualify for court appointed. You can waive your right to counsel and represent yourself. Another option, you might be able to apply for diversion. That is where you apply, and if the county attorney approves you for diversion, you would pay agreed upon fines, costs, get your insurance current, and pay a diversion fee, and she'd dismiss the charges and keep them off your record. If you want to talk about diversion or anything else with your attorney, you certainly will have the opportunity to do that. Your pleas, you have a choice of pleas. You can plead not guilty and we can set this for trial at a later date. You can plead guilty, admitting the charge, and we would proceed with sentencing. Or you could plead no contest, which is neither admitting nor denying the charges, but you'd still most likely be found guilty and we'd proceed to sentencing. If you want to look into diversion, we'll enter a not guilty plea to give you time to do that. You can always change your plea, but once you're convicted, pre-trial diversion is off the table. So
probably not eligible for diversion based on his driving record.
Oh, okay. Well, do you want to talk to an attorney then and discuss whether or not you have a defense? Or?
No, Your Honor, I would like to request a declaratory judgment due to there is no agreement for my performance under any agreement or commission of this court.
Are you really under the impression that the rest of us care whether you personally agree with the law? The second you step out of your home and into public society, you're bound by the same social contract as everyone else. That's how civilization works. You don't get to opt out because you don't like the rules. Agreement isn't required. Compliance is.
Well, I don't need an agreement from you, sir. So if I were...
Well, Your Honor, I simply do not understand the nature and cause of the accusation with regard to the jurisdiction of the venue and nature of this action until the prosecutor properly alleges them there. I cannot enter a plea to the charge until I have the opportunity to raise a meaningful defense on my behalf.
All right, I will then, since you cannot enter a plea today, I will enter a not guilty plea for you and give you
I
time.
object, Your Honor. I object to you entering a plea to me because I must understand the nature and cause of these accusations. So I do not agree to you entering a plea on my behalf.
Well, your position is taken and I'm still going to do it. I will note your objection for the record, but I'm going to enter a not guilty plea.
Well,
Now,
I object to you entering
your
a plea on
objection
my
is
behalf.
noted. Your objection is noted, and if the time comes, you can appeal that to the Court of Appeals. Now, on the issue
Well,
of
who is,
attorney,
Your Honor, I would like to ask, who bring these charges against me? I should have the right to
all
question.
right, we're not going to have this debate right now. I've told you your charges. I've told you the state of Kansas has filed those through its attorney, Jill Gillette. Now,
Well, I would like to
okay,
call
I'm
the state to the, I would like to call the state to the stand, Your Honor.
We're not doing
The
that,
state bringing
Tim.
charges against me, who is it? How did I injure the state?
All right, this is your first appearance. I advise you of your rights. I advise you of your charges and possible
Your Honor,
penalty.
I object to the proceeding, for I do not know the nature and cause of the
I'm
proceeding.
entering a not guilty plea. Missy, when is?
I object to you entering I object to you entering a plea on my behalf. I do not grant you that right.
Missy?
The court date,
You're supposed to act as a trustee.
Sir, you
Now,
need to stop. You're being in contempt of court. You need to stop or I'll have the officer assist you in stopping.
What truly baffles me is that Judge Webster keeps giving him opportunity after opportunity to walk away, but he treats the courtroom like it's some kind of strategy game that I in his mind. This doesn't end until he either wins with a dismissal or loses with jail time. So go ahead. Take a guess. Where do you think this is headed?
Missy?
well, Your Honor, I would like to also bring to you
September
according to
27th.
USC 12203.
Deputy Miles.
And also
could you,
Article 3, the judge must operate in good faith and good behavior. So therefore, if you're making a threat towards me, then
Deputy,
that's
if he's going to
urging
keep
me to
being
perform in your
contentious, I'm going to
court.
have you take him into custody on contempt.
Then that would be illegal search and seizures, Your Honor.
Wouldn't you need to go back?
It will.
All right,
It's
Missy.
false
I
imprisonment.
want you to stop talking or you can go upstairs to the county jail. Now, do you want to go to jail tonight?
Your Honor, again, Title
Deputy
40
Miles, could you come in and
USC.
assist the defendant?
September 27th at 9 o'clock will be the court date.
September 27th, you said 9 o'clock?
Yes.
9 a.m. You must be back here, sir, in person at the courthouse, or you will be arrested for failure to come to court.
Your Honor.
Now, that deputy there is going to take you into custody if you cannot control yourself through the remainder of this hearing.
I'm not doing anything. I'm just enforcing my right, Your Honor.
All right, so your first right is to have a hearing date, and that is September 27th, 9 a.m. The
Your
second
Honor, I
right,
also have a right to understand the nature
Sir.
of this. I have a right to understand the
all
nature
right,
of
if you don't want to listen to me, you can go to jail.
Is that your order, Judge?
Do you want to hire an attorney or apply for court appointed?
No, I do not. I don't need to hire an attorney, Your Honor.
You want to represent yourself?
I don't need to hire an attorney. I would like for you as the judge, Your Honor, to explain to me the nature and cause of the.
All right, I'm not going to appoint an attorney if you don't want me to. If you want, you said you don't want to hire an attorney. If you want to apply for court appointed, the officers have forms there that you can fill out. If
I
you
just
don't
want to
fill them
understand the
out,
nature
I'm
and
going-
cause.
If you don't want to fill one out, I'm going to assume you don't want an attorney. And then if you come to court September 27th at 9 a.m., you're going to be representing yourself if you don't hire or apply for court appointed. And so you've got the third issue. Does he have a bond? Looks like you do because you failed to appear February 27th at your first appearance. So bench warrant was issued, bond was set at 1,000 cash for professional surety. Looks like that was posted. Looks like you made a cash bond of $1,000. Does that sound right? You put up 1,000 cash back in July 12th?
I'm still trying to understand the nature and cause of this allegation, Your Honor.
I will continue your bond unless you get yourself hauled into jail on contempt before you leave.
If you actually wanted to understand the charges against you, you'd probably need to undo decades of bad legal advice and maybe spend some time in college and law school. But here's the reality. The Constitution guarantees your right to be informed of the charges. That's it, and Judge Webster just did exactly that.
I will continue your bond with the condition that you reappear here in person at September 27th at 9 a.m. So you've got your court date, you've got your bond, and we've talked about your lawyer. Now, you're wearing a U.S. Army uniform with the name Johnson on it. Are you in or have you been in the United States military?
Your Honor, I'm still trying to understand the nature and cause of the allegation, Your Honor.
All right. If you can leave the courthouse now without any further disruption, I will let you do so. But I'm going to have those officers escort you to make sure you do so. So, Ms. Gillette, anything further?
Your Honor, it is your oath to explain the nature and cause of the allegation against me. Are you failing to do that?
All right. You can either walk out the front door with the officers, or you can walk upstairs to the county jail with the officers. The choice is yours. Either leave.
Your Honor, I'm trying to understand.
Disruptively.
I'm not being disruptive. I'm just trying to understand the nature and cause of the charge.
All right, officers. I'm gonna close.
What am I doing? I'm sitting here trying to understand the charge.
If he gives any more grief.
All I'm asking is to understand the charges. This is for the record. You said it's for the record, so I'm trying to understand what am I being charged?
The charges. Goodbye, sir.
I just want to understand the nature and cause of the charges, Your Honor. That's all I ask. It is your oath to give that.
If you tell me what kind of questions you have, I'll be happy to answer them. But I've already told you.
Okay. Under what jurisdiction is the charges being brought to me under?
All the
State of
jurisdictions.
Kansas is charging
All
you
of them.
82 and a 65 and operating in a motor vehicle without liability insurance on January 4th, 2024 in Greenwood County, Kansas. You failed to appear for your first appearance, and a bench warrant was issued, and you were arrested, and you made a bond of 1,000 cash or surety, posting a cash bond. Now you have to go to court, and you have to answer those charges. You can
Your Honor,
have a trial if you like, and the burden will be on the state of Kansas to either prove or disprove. If they can't prove it beyond a reasonable doubt, you're let go.
Well, I'm still trying to understand under what jurisdiction am I being charged under, Your Honor? That's all I'm trying to understand.
You're being charged under the jurisdiction of the state of Kansas under its criminal law.
According to the Constitution, there are only two jurisdictions.
All right, we'll have that on a later date. We'll be at recess, officers. Please escort him one way or the other, depending on his behavior.
But I'm still not understanding what you're charging me with.
Goodbye. We are adjourned.
But if she's the judge, I'm supposed to have clear and concise of what I'm being charged with. I'm not giving y'all a problem. I'm trying to.
Put you in handcuffs.
Well, I'm waiting on this, Your Honor, to explain.
All right, Missy.
But that's it.
That's our last case on the docket, isn't it?
This is not good.
Yes.
All right. All right. Ms. Gillette, I'll see you at 3:30 docket.
Your Honor, can I please go home? Your Honor, can I please go home? I'll leave.
All right. Well.
Can I go home?
Oh, you can absolutely go home. If by home you mean the Greenwood County Jail in Kansas, if you truly wanted to return to your actual house and your equally misguided spouse, you could have done that by staying quiet during any of the multiple times Judge Webster instructed you to, but that would have required self-control. And speaking of your better half, let's take a look at how she manages to talk herself into some unnecessary jail time as well.
All right, I'm looking for a Johnson. Do I have a Johnson?
Yes, you do. I am
Danny?
here. Can you hear me?
Yes, but you're not the Johnson I was looking for, but I will take your case up. I have a Danny Johnson, and well, don't I have her on here? Oh, she's Stasha Carter. Do you go by Johnson also?
Okay, so I'm here for Danny Johnson.
Oh, are you the attorney?
I'm a representative for him.
What does that
And
mean?
that means I'm his wife, and we sent
Okay, are you an
documentation.
attorney?
I'm an attorney, in fact.
You're not an attorney at law?
No.
Okay. So when you
So
say you're an
Mr.
attorney, in fact, you're not an attorney, but you're here on his behalf as a citizen. Is that
No,
right?
I'm not a citizen. I'm not a citizen. But let me state for the record, Mr. Johnson is under doctor's care. He's in recovery. We sent the documentation over to the courts to show that, to show proof of that. We also reserve our rights to any and all reproduction of or distributing of videos on social media platform. And we request the matter to be rescheduled at a later time when he can get through his recovery period.
All right. Mr. Johnson failed to appear at his first appearance, February 27, 2024. August 13th, 2024, he appeared. We took formal first appearance. He entered a not guilty plea. Actually, he objected, I think, to just about everything that we did. He was argumentative, disrespectful, interfered with court proceedings. I believe he was
Your Honor. I think he was
stop.
He was.
You don't have any standing here today, Miss Carter, because you're not his lawyer. You're not him.
I'm not Miss Carter. I'm not Miss Carter.
Then why does your screen say Sasha Carter?
That's what it says, but I'm not Miss Carter. And it says,
Who are you? Who are you? Before I disconnect you from these proceedings, because you don't have standing to be here. What's your name?
Well, again, Mr. Johnson is under doctor's
Do you want to tell me your name?
He's here. I've already gave you my name, ma'am. I'm his
Well,
wife.
then say it again, because I must have missed it. What's your name?
Miss Johnson.
What's your first name?
Nicole.
How do you spell that, please?
Nicole.
Nicole Johnson. And you said you're his wife. Is that correct?
That's correct. That's correct.
You're his legal wife. Okay. Now, if you'll let me continue, and if you won't, then we'll have to remove you from the proceedings. On August 13th, 2024, he became, as I said, argumentative, disrespectful, and interfered with the court proceedings. I found him in contempt. He was arrested, and he was to serve 24 hours in jail. And then, as I recall, the military put a hold on him, and because of whatever reasons, he served more than 24 hours. But he was told to be back here September 27th. And on September 27th, there was an issue that he either was or was not receiving medical service, and he wanted a continuance, and we ultimately continued it to today. Now, that's been a month ago, and you say he's still under doctor's care and can't be here today, or is that, what were you trying to explain there?
What I was expressing, ma'am, is that he was in surgery on the day of the court date. He had
30 days ago, he was in surgery. Okay.
Correct. The doctor put him under doctor's orders to stay on bed rest. And that's where he's currently residing on bed rest. And we sent in the documentation to the courts and the doctor. The doctor notified the courts that he's not to appear because he can't travel and he can't fly due to his surgery.
And we've made it clear to him that he can appear by Zoom. So I'm
Well,
going
ma'am,
to issue a bench warrant, bond
hold on one
forfeiture.
second. Hold on one second, ma'am, because he is here. He can hear you, but
Well, then put him
I
on
just
here.
oh he's on here, but he's in a recovery bed, ma'am, and it's a violation of his rights, his HIPAA rights to be shown and be broadcasted all across social media as far as
Bench warrant, bond forfeiture, no bond, hold.
Ms. West.
You know how it goes. Couples who show up to court together sometimes share more than just a ride. Sometimes they share the contempt charge too, and she's just getting started and she's about to learn the hard way that being a Zoom warrior in court isn't a personality trait. It comes with consequences. Very real ones. Now let's move on to the final hearing, which took place about a week ago. It was supposed to be in person, but he had to appear by phone instead, and this time, he actually had a legitimate reason.
Oh, now do you want to be on here, sir?
Well, I'm
you
first of all,
under duress.
Are you
Under
voluntarily appearing, Mr. Johnson?
No, under duress.
I'm not.
Okay, I'm not duressing you at all. You don't have to be here.
Can I speak, please? I just want to let you know I'm on a series of medication that alter my. I'm on a like medication that I'm supposed to be on bed rest from my procedure for the next 8 weeks and for the following 8 weeks, and then I'm supposed to start my recovery. But I have reached out to the courts. I have had the hospital reach out to the courts in reference to my procedure and my process. I have requested a continuation. I have also sent in letters to request evidence from the case to continue the case prior to these procedures that I have not got a response back. So
Certified mail.
I sent it out registered mail that the courts received, I think on the 23rd, in requesting evidence of the case to continue prior to my surgery, but having the surgeon
It's an unforeseen circumstance.
Ma'am, I want you out of the case now. You're not his lawyer. He's talking, he's representing
Ma'am, the
himself.
creator,
You're out.
the creator made me his wife, and
I will find you in contempt of court.
ma'am.
Stop talking, Miss Johnson.
Okay.
Now, both of you stop for just a moment. Miss Gillette, you haven't had a chance to say anything on this. Do you wish to be heard?
Because you're acting like the attorney.
I'm acting like the court, and you owe me $50, ma'am, for contempt. And if you have another outburst, it's going to go up, and it will be enforced. $50 direct contempt by Nicole Johnson for her interruption of the proceedings. Ms. Gillette, do you wish to be heard?
Good luck with that.
Ms. Gillette?
Sorry, I was making notes, Your Honor. In this matter, there have been lots of issues with Mr. Johnson. There is a letter here. I don't know if it came directly to my office or through the court. It's through the court because it was filed in the court file of
All right,
his.
so when you say through the court, you mean it went to the clerk?
It went to the clerk
Okay.
and was file stamped. There
And
is
it may or may not have made its way to my office, but if it has, I haven't seen it. For the record, go ahead, please.
there is a note from seen September 25th, 24. His other hearing would have been the 27th. Asking he be excused. We've had lots of issues with Mr. Johnson in the past. I am taking into consideration that he has provided a doctor's note and information about
Okay.
that
But
visit.
that was the last hearing. What do you have, if anything, for today from the doctor?
That was received. It was file stamped 9/27. I don't know if he's recovering or not. I can't tell you anything about that. So if he is on medication, Judge, I don't want to have anything substantive unless he's not taking pain meds. So I would move it over to November, for him to be here, present, and, he needs to understand that attorneys can speak for individuals, but not family members unless there's some
You not be,
sort of.
you won't be released in November, ma'am.
Ma'am.
So,
$100 fine or for contempt against Miss Johnson.
Oh, we know you're not worried about it, honestly. That's part of what makes this so fascinating to watch.
Okay, now, Mr. Carter, you may speak. Yes, sir. Now, if you're
ma'am, do you even know who you're talking to, ma'am? Because you're calling all these names. Which name, who are you speaking to?
you told me your name was Nicole Johnson. I'm
Correct. So you calling Carter, and I expressed to you that nobody's here is Carter.
Well, don't have to put Carter on your screen if you're not Carter.
Ma'am, we made the point to be here in court today, ma'am.
You
and that's under the
talking
unforeseen circumstance. He's still
all
here.
Right, I'm going to end this talk. This court is over. Bench warrant. If you don't stop and get out of it. If you don't want this bench warrant, you be out of this conversation and let me communicate with the defendant.
Ma'am,
obviously, Mr. Carter doesn't have any control over you.
Anything.
Okay, Mr. Carter, I'm going to have to end this court because the woman won't shut up. And I'm going to have to leave a bench warrant. If you can get her to shut up and stay out of the conversation, you and I, sir, can have a hearing. Now, okay, how much time do you need this continued, Mr. Carter?
The doctor can send over the information.
I will request.
Mr. Johnson, I'm sorry, Missy, can you get that?
Hey, I'm trying to explain to you. The doctor told me it's going to be 3 to 6 months for my recovery.
3 to 6 months.
I had a T10, T11 procedure. So it's a middle back procedure. Like I said, I haven't even started physical therapy yet.
Do you have an attorney, or would you be willing to take a court-appointed attorney?
As far as the attorney, all I would coming to do is, because I'm on medication, I don't want the court hold anything against me that I may say due to the type of medication I'm on. And two is the fact that I am requesting a continuation. I know y'all saying I've been whatever, but at the end of the day, I'm requesting a continuation at least to December, late December or January.
All right, we're going to set this over for trial. It'll be for bench trial. And what the doctor told you you'd be in recovery for how long?
I'll be 3 to 6 months for recovery.
So this is October, November, December, January. All right, January 31st will be your bench trial. Now, did I understand that someone did receive something from his doctor today or recently? Ms. Gillette, you were talking about something from a month ago.
What time?
Yes, it was filed September 27th. It said he had surgery.
Yeah, we continued that hearing based on that letter. We continued it to today. But has anybody seen anything more recently?
No.
I think the wife was reading something that said he couldn't travel, but I don't think it said anything about appearing by Zoom. I think it just said he couldn't travel or appear in that fashion. But that's what we need to make sure come January, that the doctor understands this can all be done by Zoom. And again, Mr. Johnson, would you consider appointment of an attorney to represent you?
Not at this moment, Your Honor. Like I said, I'm on medication.
Well, an attorney could sure help you navigate through this court system. I understand you wanted to represent yourself, but the attorney could sure help you.
I don't need an attorney at this moment.
All right, we'll document that for the record, Ms. Gillette, in the journal entry, that he still does not want an attorney, that we are continuing this again at the defendant's request for medical reasons to January 31st, 11 a.m. Now that's going to be for bench trial, so keep that in mind. The state will have their witnesses ready, and if you have any witnesses, you'll need to have them ready. Hopefully, you won't be under medications January 31st or in any situation that's going to affect that. But I won't issue the bench warrant. Nicole Johnson does owe me $100, or she owes the court $100. I'm going to give her 10 days to pay that. If she doesn't pay it, then she's going to face more contempt. That payment needs to be paid, Ms. Johnson, to the clerk of the district court. And that is in Eureka, Kansas at 311 North Main. And make sure you put on there contempt for case number GW 2024 TR22. That's, and put on there that it's for payment for direct contempt of Nicole Johnson for continued, well, you won't have to put on there other than for contempt, but I do want the rest of it put in the journal entry, Miss Gillette.
Well, if somebody tries to defend themselves, it's contempt. Exercise their rights, it's contempt.
Ma'am, you don't have any rights in this hearing today.
I do. I'm not a citizen, ma'am.
Using your bond money to pay the fine might have worked if you had honored the conditions of your bond. That means showing up to court and not catching new charges along the way, but you violated those conditions. When you break the terms of your bond, you void that agreement. That's why the county keeps the money. And let's not forget, your charges carry potential jail time. So simply offering to just pay the fine isn't even an option.
I don't care what you consider yourself. You do not have any right to come into any court of law and start interrupting and delaying the procedures and absolutely deliberately and intentionally disobeying what the court instructs you.
Ma'am, I called the county attorney yesterday. I called the clerk yesterday.
I am going to tell you to stop talking one more time before I
know, because you don't want me to express my rights.
This is not your hearing. This is not about you. I really hate to have to send the sheriff to whatever state you're in.
You have not given no lawful consideration to this matter,
Mr. Johnson.
The doctor's care. He has provided all the documentation to show that he's under the doctor's care, ma'am, and you have not given no consideration to that.
You are so fortunate that you're not here in person, or you'd be locked up right now.
Yeah, I am fortunate.
And you'll be locked up if he is not here in person. Mr. Johnson is ordered to appear in person for bench trial January 31st, 11 a.m. Ms. Carter?
Yeah, because you want to retaliate against him, don't you?
Ms. Carter now owes $200 in fines, and I'm disconnecting this call so I don't have to send the Greenwood County Sheriff to whatever state she's in to get her picked up and locked up for contempt. This hearing is adjourned.
Ma'am, every time somebody expresses their lawful rights to defend themselves, you hold them in contempt. Why is that? You are a judge. You are compelled to provide protection for we the people. You acting as an attorney, giving advice to people, bringing people down, and he's in a situation to where he's under doctor's orders. It's a shame that you still wanted him to present himself under the doctor's orders of bed rest and medication before the court.
Put the camera on yourself when you talk to me, Ms. Carter,
and you can
Ms.
put it out across social media, and you can talk down on them, and you can make money off of it because you go and you spread it, and then you get up all these views.
Put the camera on yourself if you want to tell me off, Miss Johnson.
I can put the camera where I want to. That's my legal right, ma'am.
You are to appear. I will send the orders for you to appear personally because you're going to serve some time for this disrespect. Miss Johnson.
It's disrespect with what you having him do on camera.
Disconnect her. This court hearing is adjourned.
Yeah, disconnect yourself because you're unlawful.
All right, let's take up Danny Lewis Johnson. Will be on the record in 2024 TR22 and 2024 TR541. Paul E. Dean for the state. Danny Johnson, are you present?
He is not present, Your Honor, and I have a note.
I think he's on the phone.
Oh, he is? Okay.
Now that I think about it, Missy, you said he is in.
I got an email.
Go ahead.
Yeah, I think so. I got an email from somebody at Leavenworth.
Yes, he is being held by, currently held for a court martial and is not going to be released until the court martial is completed. Therefore, at this point in time, Your Honor, I would ask that we issue bench warrants in both of the cases that are before this court with Danny Johnson, authorizing no bond.
He was ordered to be present in the courthouse today.
I am here.
He is here on the phone.
Well, that's on the phone is not in person at the courthouse, and he is in custody. So I need to issue warrants to keep holds on him. Mr. Johnson, is that you that I'm speaking to?
Yes, I was in the midst, got cleared by the doctor to come back, and when I came back, they apprehended me and said I was a deserter because I waited till the doctor to release me to come back. I was prepared to come there.
Sir, I'd recommend you not to be making statements in regards to a pending criminal court martial.
Well, I'm not worried about that.
If you don't want to be called a sovereign citizen, stop acting like one that after making a series of bizarre legal claims, he ultimately just requests a jury trial and abandons the rest. Situations like this are exactly why public defenders exist, and I am sure those filings were placed in the extremely important stack somewhere. Until then, he and his wife can enjoy their separate stays at what I am sure is not a 5-star resort. That's it for today's video. My next upload will be part 2 of Karen who tried to sue me and lost. If you liked the video, hit the like button. If you didn't, hit dislike. But either way, leave a comment below and subscribe with notifications on so you don't miss what's coming next.